Welcome to today's Explainer. We're going to dive into a massive, frankly existential crisis that is quietly unfolding right now in modern legal practice. Everyone is talking about AI in the courtroom, but today we're looking at something much, much deeper. We're going to break down exactly why AI actively and silently threatens legal privilege.
Okay, let's start by challenging a really common assumption. Pretty much everyone is terrified of AI hallucinating fake cases, right? I mean, we've all seen the crazy headlines about lawyers getting sanctioned for submitting totally fabricated citations to a judge. But we actually need to peel the onion a bit here. We need to look past those obvious headlines at a much darker, completely invisible threat. Ask yourself this. What if the absolute biggest danger of AI isn't what it makes up, but what it secretly keeps?
It's kind of a tale of two threats. On one hand, you have the visible risk, right? AI inventing fake case citations that embarrass lawyers in open court. It's bad, sure, but you catch it immediately when the opposing counsel literally can't find the case. On the other hand, you have the invisible risk. This is the silent handover of client secrets and the catastrophic loss of legal professional privilege. And here's the scary part. This danger might only surface years down the line during a massive data breach, a sudden subpoena, or, honestly, just a quiet change in a tech company's user policy that nobody actually bothered to read. So, to understand how to protect ourselves, here is our roadmap for today's explainer. 1. The invisible AI danger. 2. What happens to your data? 3. The legal privilege trap. 4. Ranking the AI tools. And finally, 5. Safeguarding client secrets. Let's dive right in. Starting with Section 1. The invisible AI danger, a silent threat to confidentiality. Let's explore why hitting send on a chatbot is way more dangerous than you might think. Judge Dean P. Morzone Casey actually hit the nail on the head in his recent paper. He points out that this threat is so perilous, specifically because it leaves no immediate trace. He states, the danger to confidentiality is serious, precisely because it is invisible. A breach of confidence may never show itself at all until a data breach or a subpoena. It basically acts like a ticking time bomb for confidential client data. You just don't know the bomb is even there until it goes off and ruins your case. Moving to Section 2. What happens to your data? We need to demystify the AI black box. To grasp how privilege is actually lost, we have to look at the mechanics of what happens to a document the exact second it leaves your screen. If we break down the data's journey step by step, the vulnerability becomes pretty obvious. Step 1 is transmission. Your data travels to the server and it's fully encrypted. Good so far. Step 2, ingestion. It gets broken into readable fragments or tokens. But Step 3, wow. Step 3 is the real danger zone, inference. To actually give you an answer, the AI model has to eventually read your client's words in plain, unencrypted text. And finally, Step 4. Logging and downstream uses, where your data might sit on a server or be actively learned by the machine. So while encryption protects the data while it's moving, the AI simply cannot be blind to your text if you expect it to actually do its job. Now, this brings us to a really critical distinction that separates a totally safe tool from a disastrous one: answering versus learning. When a model is just answering, it uses your text to reply and then sets it aside. Done. But a model that learns from your inputs, it absorbs your text to train its future behavior. That opens a terrifying door. You're risking exposing your highly confidential legal brief to complete strangers, maybe weeks or months later in a totally unrelated chat window. All right, on to Section 3, the legal privilege trap. Let's look at why AI is absolutely not a secure filing cabinet, and how this technical reality creates a massive legal trap. We often justify using new tech by comparing it to things we already trust, right? Things like email or Dropbox. But an AI company is not a passive mail carrier. A carrier just holds encrypted files temporarily to pass them along. An AI model, though, is the ultimate recipient. It takes in readable, plain text as its final destination and processes it. When you feed material into an AI tool, you have officially disclosed it to the company that owns the tool. And under the law of confidence, handing over privileged material to a third-party recipient without strict, legally enforceable protections is a huge mistake. And this setup creates a massive contract gap that can literally destroy privilege. There are two major privacy gaps you've got to watch out for. First, you have no direct confidentiality contract when you use a free public AI tool. You are just handing data over on their standard terms. And let's be honest with ourselves, nobody is reading those before clicking accept.
Second, and this is the really sneaky one, even if you buy a specialized legal AI wrapper, that wrapper usually relies on a third-party base model, like OpenAI or Anthropic, operating in the background, often offshore. You, the lawyer, typically have absolutely no direct contract with that base model provider. You're relying on a promise between two other tech companies that you cannot legally enforce in court.
Actually, the courts are already recognizing this exact trap. Just look at the recent U.S. versus Hepner precedent. In this case, an executive inputted sensitive defense strategies into a generative AI platform to brainstorm before he even talked to his lawyers. Well, the judge ruled that doing this completely waived his legal privilege because the AI platform is a third-party entity. It's not a lawyer. Plus, its terms permitted disclosure to others. Just sharing it with the AI destroyed the confidentiality required for privilege to exist in the first place. No way around it.
So, Section 4, ranking the AI tools. Let's navigate the ladder of risk since not all tools are created equal, and one bad choice can frankly blow up your whole case.
Think of AI tools on a ladder of risk. Up at the top, we have severe danger, free public chatbots. They learn from your text, there's no contract, and they keep your data. Literally never put client data in these. In the middle, you have moderate risk, paid business versions. You get a contract, they promise not to train on your data, but that data might still be processed on an offshore server, which means it's reachable by foreign subpoenas. But down at the absolute lowest risk level, we find sovereign onshore models. These tools don't train large language models on your data. You hold direct contracts with them, and all your data stays strictly within your own legal jurisdiction. To give you a concrete example, let's look at a sovereign AI tool like JurisTechne. They completely eliminate the hallucination and privacy risks by using a closed, deterministic knowledge graph instead of a generative language model. But even more importantly for legal privilege, it's an Australian sovereign model. That means the tool is hosted onshore and data is processed onshore under a direct confidentiality agreement with the lawyer. The data never leaves the reach of the local courts that protect your privilege. That is a game changer. Okay, finally, Section 5, safeguarding client secrets. Let's wrap up with some concrete habits for the digital age, exactly what you need to do to protect your practice immediately.
Look, these are your absolute non-negotiables. Number 1, always remove identifying details first. De-identify the data before it goes anywhere. Number 2, only use tools with a direct, enforceable business contract. 3, verify exactly where those sub-processors are geographically located. Offshore servers just invite offshore legal headaches. 4, prefer zero storage arrangements so the AI just forgets everything the moment it answers. And number 5, proactively warn your clients about using AI for their legal problems. You definitely don't want them accidentally waiving their own privilege like we saw in the Hepner case. I really want to leave you with this incredibly stark warning from legal regulators. They state, a lawyer who treats a free public chatbot as a private filing cabinet has, in substance, done something close to publishing the brief. Let that sink in. Using a public tool for client data isn't just a little risky. It's practically the same as handing your confidential case files out to random people on a crowded street corner. So as we close out this explainer, I have a challenge for you. Look at your daily workflow and ask yourself a very tough question. Next time you hit copy and paste on a sensitive, privileged document, do you truly know who is receiving it? And more importantly, do you know what they are going to do with it tomorrow? Thanks so much for joining me today, and stay sharp out there.